All right, so let's begin with our panel discussion two. And our panel discussion two says cross-border IP disputes and infringement cases, a global perspective. And we have our key panelists joining in. We have Gargi Nadkarni. She's a senior manager, portfolio planning, Sun Pharmaceutical Industries Limited. Our other panelist is K. Brian Matlock, partner and co-chair, corporate and intellectual property law, FSG lawyers. He will be joining up soon. And the moderator for the session, Michaël de Vroey. He's an advocate lawyer, BakerMcKenzie. So over to you, Michaël.
Good day, everyone. We will be having a panel discussion today on cross-border IP disputes and infringement cases, a global perspective. So what's interesting today is that we have three panelists from different continents, regions in the world. So that's really to cover the globe, let's say. So I am Michaël de Vroey. I'm a senior associate in the Antwerp office of BakerMcKenzie in Belgium. I specialize in IP and litigation in the retail and the healthcare industries. My IP practice encompasses all contentious and non-contentious aspects of intellectual property law, including trademark, copyrights, designs, patents, trade secrets, and related issues. And I've been involved in domestic and cross-border IP litigation cases before the Belgian and EU courts and administrative bodies. We also have Gargi Nadkarni. She's a senior manager at Sun Pharmaceutical Industries Limited. Has around 30 years of experience in IP litigation and business development. Her role currently includes identifying robust generic products for regulated markets and 505 opportunities. She started her career as an IP professional, where she worked hand in hand with R&D and outside counsel to develop effective IP strategy for generic products. Over the years, her repertoire has evolved into a rich amalgam of technical, legal, commercial, and regulatory aspects of product selection and development. And she has extensive experience in patent litigation, settlement negotiations, and the entire gamut of activities. And she's an expert in shaping IP strategy. And we will be soon inviting also Brian Matlock. He's a partner at FSG Lawyers in the US, California. He has broad experience in corporate law, securities regulation, mergers, acquisitions, and technology transactions and IP matters. In addition to legal practice, Brian has deep experience in technology commercialization and licensing in a university setting and working with tech startups. So as for the agenda today, in this session, Gargi will share her experience in relation to patents and more particularly the relation to the pharma industry. Then Brian will share his insights and experience in relation to US copyright, trade secrets, and trademarks. And then I will go into more detail on IP infringements online and give you some guidance in case law from an EU perspective. So that's the agenda for today. And so without further ado, I will give the floor to Gargi so that you can explain some more on patents in pharma. And maybe the first question that I have for her is the difference in cross-border infringement issues between pharmaceutical and other industries. So maybe Gargi, if you could inform us on that, that would be great. Thanks.
Sure. Thank you for the kind introduction, Michaël. Yeah. So what is different between what is so unique about the pharmaceutical industry? So the thing is that like every other like every other large conglomerate, business for pharmaceutical companies is not confined to one country, right? Whereas patents are okay. So I was saying that so most of the pharmaceutical companies, they operate within different jurisdictions. Like we'll rarely see that a company is based out of one country only. I mean, although major conglomerates would have their own national subsidiaries, located in different countries. Whereas patents, like other intellectual property rights, they are basically, it's a jurisdictional right. So, given these two contrasting aspects, and the fact that in today's age, goods and services move seamlessly across national borders, it is imperative for both a patentee and a generic pharmaceutical industry to consider the effects of cross-border patent infringement. More so, there may be a lot of startups and some smaller companies that do not have large scale manufacturing facilities, and they may rely on contract manufacturing organizations to carry out the manufacturing services for their drug products. So these are the two things which which greatly impact the cross border infringement aspects. Secondly, so like unlike other industries, especially relating to pharmaceutical patents, a patentee would get his patent much earlier in the development stage, whereas he would actually sell his product after the FDA or the other regulatory bodies approve the drug product. So there would be a gap of certain number of years, and to compensate pharmaceutical companies and to incentivize research and development, many regulated markets often have a SPC or a patent term extension, which is basically unique to pharma industry. And this is basically an extension of 20 years of the patent right, which is granted, and this may vary from 1 year to 5 years. There are certain other countries which, like India, for example, which do not confer these term extensions. So what basically happens is, while you have manufacturing setups in different countries, you may not have the patent expiring on the same day. The patent may be originating from the same application, but it may not expire on the same day because of these extensions that are granted. So then that becomes an issue, and I know businesses like ours, like Sun Pharma is majorly a generic pharma or pharmaceutical company, and we have to then think about a lot of these things as to where we are manufacturing, what is the patent expiry date there, and then where we would be exporting the product to. So all these factors need to be practically considered. Like, for example, we have several times we have kind of changed our manufacturing plans in order to not infringe somebody's patent. So these kind of things keep happening, which is why I feel because of these change in dates due to the term extension, the pharmaceutical industry is slightly different from the other industries in terms of cross-border infringement issues.
Okay. A second question that I had is, can the manufacture of pharmaceuticals for export to other countries constitute an infringement?
Right. Okay. So this is actually this is a very interesting question, and there's a lot of case law surrounding this. So basically, the simple answer to this question is that this basically is dependent on the jurisdiction that you're looking at. It depends from country to country. Like, for example, in India, we have a specific law which categorically states that a foreign vessel which may be present temporarily or accidentally on Indian soil or in Indian waters would not, like, even if it contains or uses certain goods that may actually otherwise constitute infringement, it would still not be deemed to infringe a patent in India. So if suppose, what it basically means is that if an airplane is carrying goods for export into another country, and it has somehow landed in India, and if it is going through customs, but if the intended sale is not going to be in India, then the Indian patent law kind of does not consider this to be infringement. Now, this is regarding like if the drug was manufactured elsewhere and if it was just passing through India. Now, the interesting thing is that in the Indian Patent Act, under Section 48 of the Act, basically the Section 48 describes the patentee's rights under the Act. And as we all know, a patentee can exclude others from making, using, selling, or offering to sell and import a patented product. Right. So I remember a recent case involving the drug sitagliptin, wherein the innovator or the patentee Merck sued Sanjeev Gupta and a few other people who were actually manufacturing the drug in India, but that drug was supposed to be exported and not sold in India. So it was intended for manufacturing. It was intended for commercializing or sale of the drug outside of the Indian territory. However, Merck sued these guys for patent infringement because their compound patent covering the drug was still alive. So during the case, like the judge, okay, so the defendant basically argued that this Section 48 would not specifically apply because that Section 48 does not specify that whether the manufacturing is for export or whether that manufacturing is for sale within India. But however, the judge struck down this argument and ruled that any manufacture for a commercial purpose anywhere in the world, if that manufacture is done within India, then this will constitute infringement. So the long and short of this is that if you are manufacturing for a commercial use, even if you're not going to sell it within India or within the territory, it would still constitute infringement. Now, this term is interesting because, again, and this is specific to the pharma industry, is that we have a BOLAR provision which basically exempts a pharmaceutical company from infringement if they are using the invention or manufacturing reasonable quantities of the patented invention for research and development purposes. Because a company has to generate data for submitting their generic dossier, so that has to be done 1 or 2 or 3 years in earlier of the patent expiry, so that you can launch or you can get approval and then launch within the interested territory on patent launch. So under the BOLAR provisions, a company is allowed to manufacture and use the patented invention if it is for generating data to submit to regulatory authorities for approval. But this is only for generating data and only for research and development purposes. If you are manufacturing for commercial use, then that is not allowed and that would constitute infringement. Now, this was specifically about India. In Europe, the situation is very interesting because of this SPC, or the Supplementary Protection Certificate, which extends the term of the patent. In India, we don't have that. We don't have a patent term extension, but in Europe and in US, this gets interesting. So what happens is, what used to happen rather is prior to 2019, generic companies were barred from manufacturing even for export. All right. Even during after the normal expiry of the patent and when the SPC kicks in, and during the term of the SPC, these companies were not allowed to manufacture even if they were going to sell it outside Europe. So what happened actually was people started moving out of Europe and people started going to started going to countries which did not have these patent term extensions, and so basically this was kind of reducing this was basically kind of downgrading Europe's economy, and it was impacting the economy. So because of that, in the European Union in 2019, they brought out a regulation, which I have the number 2019/933. So according to this resolution, it provides exemption on the supplementary protection certificate for exporting and stockpiling API as well as drug products. So, provided that the manufacturer should notify the SPC holder or the patentee that he's going to do a manufacture during the SPC term, and also the patent office, and this notification should be given like 3 months prior to his intended manufacture. So now so this was basically done to incentivize local manufacturing in Europe, and now since 2019 companies do this manufacturing after the normal expiry of the patent, and even when the SPC exists. So that was a long answer to your question.
Thanks, Gargi. This is very interesting, and as you say, there are similarities with the situation in Europe, but there are also notable differences with the situation in India. A third question that I wanted to raise and ask you has to do with jurisdiction of the courts. So which courts will have jurisdiction in a patent cross-border infringement issue?
Right. So basically, like for cross-border jurisdictions, it basically means that a national court would be allowed to take decisions such as injunctions, which would have effect outside its national jurisdiction, right? So this is more of importance in the European Union, where the borders are fluid and there is free movement of goods and services and trade across these borders. So so there's a regulation, which is Article 4 of the Brussels regulation, provides that a person domiciled in a European Union member state shall, irrespective of their nationality, be sued in the courts of that member state. It also the Article 8 of this also says that in case of a multiple number of defendants, a person may be sued in the courts for the place where any of these defendants are domiciled or reside. So basically, this was to introduce a simplified mechanism wherein a judgment, if it was delivered in, say, suppose Germany or in Netherlands, that would be enforced and recognized across all the member states of the European Union, and a patentee would not have to go into every nation and then kind of fight it out for infringement in every jurisdiction. So this was a jurisdiction issue here. However, as a counterclaim, you may know that if a patentee sues me for patent infringement, and in my answer to complaint, I can raise a counterclaim saying that the patent is invalid, right? And when that happens, this jurisdiction of a common jurisdiction loses importance, because the validity of a patent would be a national issue, and it would have to be then fought out in those particular countries. So while the infringement issue can have a common jurisdiction, the invalidity issue needs to be fought out nationally.
Yeah. Okay.
Yeah.
Thank you very much, Gargi, for this clear explanation. Welcome, Brian. Thanks for joining.
Hi, Michael. Sorry, a little trouble getting on. So,
yeah. Maybe now is a good time to hand the mic to Brian. As I said at the beginning, at the introduction of the panel discussion, is that you would be enlightening us on some U.S. copyright, trade secrets, and trademarks, the cases and issues. So over to you.
oh, okay. I have a request to full screen, so let me try to do that before I start. Didn't do it. Well, you're just going to have to, whatever screen you have to see me is what we're going to have to work with here. So, a Supreme Court case this week, Michael. I don't know if you heard about the Supreme Court's ruling for Oracle versus Google. This is a case, copyright case. It's been in the courts in the U.S. for maybe at least 10, 15 years, going back and forth. Oracle has won of decisions at the Federal Circuit level. But now they appealed and it went to Supreme Court, not on the issue of infringement, because I think there was a lot of, I think basically the issue the Supreme Court heard was, notwithstanding infringement, was there fair use for Google as an affirmative to use this this software? So just a 2-second, background on the case. The case is really about whether an API can be infringed as a copyright, whether it's copyright protectable for an application programming interface. And then the other question was whether or not there's infringement. Would there be fair use for Google, who used some of the code from the API to create the Android mobile operating system? So that's what the case is about. Google used some of this code from Java programming that Oracle had obtained when they acquired Sun Microsystems. They used it to create Android, and then the Supreme Court heard these arguments, and it really came down to, as you know, maybe, I think in fair use, there's like factors that the court weighs, and these factors are sort of like, what's the nature of the use, what's the amount of the infringing material that was used, and in this case, the Supreme Court said that they thought the use for Android was a transformative use of the code, and that was a big factor for the court. And they also thought that that Google only used as much of the code as was necessary. My understanding is that was like 11,700 lines of code, which does seem like a lot of lines of code, but compared to the total, the court didn't see it as that great and thought it was only what was required. The Supreme Court ruled for the first time in favor of Google after these judgments in favor of Oracle in the lower court. Now Supreme Court has said Google had fair use to use this code. It's an interesting case, and I don't know how it will expand relative to the Berne Convention in terms of being enforced in other parts of the world, or whether other parts of the world will see this ruling as something that would allow users to use APIs without worrying about being infringing of copyright. So we shall see how that comes out. But that case just was decided this past Monday. So a very new case law from the U.S. So I guess also I'd like to talk a couple minutes about trade secrets. There's been a few law review articles written over the last couple of years about how mechanisms of enforcing trade secrets outside of the United States on an international basis, how those would play out. And WIPO and the USPTO and others have looked at this, and they're kind of wondering what mechanisms there are. We have the International Trade Commission in the U.S. does provide for extraterritorial jurisdiction for a trade secret dispute, and articles I've seen recently have suggested that trade secret licensing is really increasing. So I think in the next few years, we should see more trade secret disputes before the courts. So I think it'll be interesting. I think the ITC could be a mechanism that someone could use. It seems to be the key, though, will be whether that misappropriator of the trade secret whether they are importing into the U.S. That may be the key for a U.S. company to get jurisdiction in other parts of the world. The trigger would be whether that party intends to try to import into the U.S. market. But trade secret is on the rise in the U.S., especially in light of the problems that patents have been having with invalidity. The Patent Trial and Appeals Board has been very active at knocking down a lot of patents the last few years. Software patents have had trouble, and many have been held to be invalid. The series of cases through the Supreme Court that have questioned the validity, the Alice case, line of cases, the cases for Mayo, the pharmaceutical case. And so there's 2 or 3 ways to try to invalidate these software patents or other kinds of patents. Really, biotech matter for that matter are facing these challenges called eligible subject matter. Basically, 101 is one of the, is sort of like originally eligible subject matter was just like an initial level to get through, and it was rarely questioned. But it's become a highly litigated area, especially through the Patent Trials and Appeals Board. So the point is, people are looking for alternatives to patents that could end up being overturned. And one of the places they're turning is the trade secrets. We just have a new statute in 2016, the Defend Trade Secrets Act. So now that gives you a very robust set of state laws, the Uniform Trade Secrets Act, and now the Defend Trade Secrets Act, which is a federal law. And I don't know how that will play out as other countries determine how they want to protect their confidential information. But know that you were Gargi, talking about jurisdiction issues. I recently had a case where a company from California had like 500 different emails with a company from China who took this trade secret information concerning a method of treatment, and it ended before the court for misappropriation in California, and the court was no jurisdiction. That after 500 emails, there was no jurisdiction, no purposeful availment, no minimum contact. So it will be interesting. It's one thing for a treaty to say that jurisdiction exists, but it's another thing for the courts to recognize that jurisdiction and enforce it. So we'll see. And to say that a court has subject matter jurisdiction is fine, but at the end of the day, the court still has to find a way to have the person or the entity to be under the jurisdiction of the court. And that's, I think, very much up in the air. I don't know if any of you are familiar with Mark Halligan's work on automated trade secret management systems, but he has a very interesting software product that he's been working on, written some papers on it with the John Marshall intellectual property group. They did a law review article. I saw that, Michael. But basically, he's like, if we can define how the IP exists in class, then, and if we define it through a series of blockchain transactions, we can set up and establish a way for a company to take millions, potentially millions of trade secret records and have the metadata be able to point to the actual document, not the actual document, but the metadata of the document could be used to establish ownership in an IP trade secret case, which I think would be very interesting and something of a trend to watch for the future and see how Mark and them do with their trade secret automated management software. So we'll see where that goes. But I think it's an interesting idea, interesting way to kind of be able to present this metadata to the court and say, here it is. It's classified. We've protected it. We were diligent and did all steps necessary. And therefore, we've got something that we think the court will find is a trade secret and can use to establish the jurisdiction that someone else had access to it. So those will be interesting. I guess one other thing that I see as a trend in cross-border IP right now is an area called the utility model, or Germany calls it the small patent. And the small patent is interesting because if you're familiar with it at all, it's a patent that doesn't go through examination. Some countries have it. The United States does not have this patent. But it's an interesting idea because essentially you have a procedure kind of like a cancellation. It's like a cancellation. You'll get your patent, utility model registered, and then you don't have those upfront costs, and you get through the patent office rather quickly for utility model. If it's challenged, then after the fact, then you can have a examination and litigation similar to an invalidity kind of proceeding, maybe something like you would have with the PTAB. But the countries, I just looked at the research this week in preparing for this talk, up 20 utility model patents in the world are up 20% over where they were, I think, last couple of years. So it's a growing area, and more countries are looking at the utility model patent as a way to address this risk of having this very expensive patent be invalidated after spending hundreds of thousands of dollars with PCT patents and protection in multiple places in the world, only to have the patent invalidated at the PTAB is a frustrating thing. But people are looking for alternatives. They're looking at trade secrets. They're looking at, can I protect my code in the API with copyright? And they're looking at things like the utility model patent as ways to try to give them some cross-border protection that could possibly be enforceable. We'll see where the utility model goes, but I think it's an interesting idea, maybe whose time has come, and maybe at some point the U.S. will look into that as well. I don't want to take all the time, Michael, but those are a few of the things that I see going on in the cross-border world for intellectual property right now.
Thanks very much, Brian, for enlightening us on these trends and the Google versus Oracle decision, which is indeed very high profile, and a lot of people have opinions about it. So it's definitely something to watch. And in respect of in terms of the trade secrets, also in Europe, that's a very hot topic. A couple of years ago, we had a trade secrets directive implemented and a national laws. So now we have a very strong, harmonized tool also to combat misappropriation and then to protect trade secrets across borders. So that's
good.
Something that's good. Yeah, sorry. No. What I wanted to touch upon is explain a little bit on the IP infringements online from an EU perspective. So as you know, the online space is increasingly becoming more important. Sales are increasing in the e-commerce world. Physical sales are, the share of physical sales is dropping vis-a-vis the online sales. And so also the same applies to the risk of counterfeits and infringements online. So there are several challenges that IP right holders are facing when enforcing their rights in an online environment. And so the first one is the issue of territoriality, because as you know, IP rights are territorially limited. So they limited to a certain jurisdiction, a country, like the EU. And so when someone is selling goods from a website in the US, having servers in yet another jurisdiction, and then selling goods to consumers in the EU, this poses a problem, because that's potentially infringing, and then how are you going to effectively enforce your rights? And so that was one of the issues that was decided last year by the Court of Justice, the European Court of Justice, in the AMS Heritage case, where it was said that it's not because a website is accessible from anywhere in the world that you can sue in Europe. For instance, it's not because a website in the US that is accessible from anywhere in the world that you can sue that website or the website owner in the EU. So there has to be more than that. And so the European Court of Justice said that EU trademark owners may take legal action in any EU member states where targeted consumers of offers are located. What the ECJ then actually said that it's irrelevant where the defendant is based, where the servers are situated, where the infringing products are located, or whether any sales occurred. So what matters is the location of the consumers being targeted. And in this specific case, these were UK consumers that were being targeted, and for that reason, the ECJ decided that UK courts had jurisdiction to determine infringement of the EU trademark in the UK. Now, obviously, this is before Brexit. So now post-Brexit, the UK is obviously no longer a part of the EU, and so but the reasoning behind it is still valid. That was a trademark case, and in the copyright space, the territoriality and the issue of jurisdiction is slightly different. We have to look at, the targeting aspect is irrelevant. And so there you can sue anywhere where the content is made accessible. So that is, of course, it leaves claimants in online copyright infringement cases in the EU with many options for countries where they can bring suit. So that's all the countries in the EU where the content was made accessible, and it's not necessary that a certain country is being targeted with the possibly infringing copyright content. What this also means is that different courts can rule on various aspects of the same dispute. So it doesn't simplify things, but so this was decided in the Pesh Hajduk case. Now the limitation there is that you can only obtain damages from the place of the court where you brought the suit in that case. If you want to claim damages for the whole of the EU, then you have to bring the claim in front of the courts where the publisher of the content is established. A second thing that I would like to touch upon is the challenge of identity and anonymity. So in an online environment, it's very easy for counterfeiters, for infringers to conceal their identity. They sometimes work under a false name, false address. And so a way to obtain this information is through intermediaries, platform providers, for instance, that are selling the goods, not themselves, but are offering their platform to do that. But there, unfortunately, the ECJ, in a case brought by Constantine Film against YouTube, said that IP right holders, yes, they have the right to obtain certain information in case of infringement, but this is really limited to the postal address, not the phone numbers, email address, IP addresses of infringing users. And so that's not really helpful to combat infringements online. I mean, postal address, if that's the only thing that you get, then that's quite limited. What we can also do, and that's been quite effective, is file an EU customs application for action. So when you're buying goods, or when when someone is selling infringing goods on through Alibaba, for instance, or from another website outside of the EU, then you can ask customs to stop these goods at the border, and that's working rather effectively for counterfeits. And then you can ask customs to destroy the goods through a simplified procedure. In the US, there is something as a John Doe lawsuit. So that's a case where a person filing a suit does not know the identity of the defendant, or thinks they might be able to identify other defendants later on. And it's also known as a fictitious defendant lawsuit or an unknown defendant suit. And so filing a John Doe lawsuit accomplishes two primary goals. First, it gets your claim filed within the statute of limitations. And two, and this is where it helps, it initiates a discovery process so that you can subpoena an online platform and internet service providers, and hopefully then identify the anonymous perpetrator. A third challenge that we've seen in the case law is the liability or secondary liability of internet service providers. And our landmark case in 2010 was Google Louis Vuitton, where it was said that Google cannot be held liable for selling keywords to companies, and that those may be keywords of certain competitors. And so if you want to stop someone from using your brand as a keyword, you cannot sue Google for that. You have to sue the advertiser for primary liability. And then also, in a recent case last year, was the case from Germany against Amazon regarding the storage of goods in Amazon's warehouse in the EU. And so the EC said that it ruled in favor of Amazon, holding that the mere storage by Amazon in the context of its online marketplace of trademark infringing goods does not constitute an infringement. This judgment is not surprising, but what is surprising is that the ECJ did not go further than this and only discussed simple storage and did not see or discuss the hypothesis where a marketplace operator is performing more than simple storage function for the customers. This is something that the Advocate General the court did not. And in the right space, there was also an interesting decision. Well, it's not a decision, so we're still waiting for the decision. But the Advocate General in the Peterson versus YouTube case had said that intermediaries such as YouTube are not directly liable for violations committed by their users, because it is the users who are putting the content online and making the content, communicating it to the public, and not YouTube in this case. In addition to that, there is of course, a defense, an exoneration for hosting for platforms, as to the hosting defense, as long as they're not actively involved in the presentation of the content. But this may change because there's a new copyright directive in the EU that is about to be transposed by the member states by 7 June 2021, so 2 months, and that includes the new liability regime. So it's likely possible that the exoneration that platforms like YouTube are enjoying will be more restricted. And the last point I wanted to give to discuss is like in this online environment, it's like sometimes it can be challenging and difficult to combat infringements and to enforce your rights in this cross-border environment. But a couple of measures that you can take, like you can file a domain name complaint to take down a website selling counterfeits, either the Unified Dispute Resolution Policy (UDRP) or the Uniform Rapid Suspension. So that's a bit faster, it's cheaper, but it's a higher threshold. This is something that is quite effective in case of counterfeiters and bad faith registration and use of names. Second thing is the platform takedown, which is working quite well. So online forms for takedowns are available at eBay, Amazon, Alibaba, Facebook. And for straightforward trademark copyright infringements, this is working pretty well to take them down. Another option that is sometimes overlooked, but is to obtain a payment method block. PayPal or Visa, because funding is often distributed in return for using a payment mechanism, and so banks and other payment service providers are obligations not to allow systems to be used for fraud purposes. So you can send them a notice to the payment service provider to close down the infringing operations. And the last thing, of course, is file for a blocking injunction, an ISP blocking injunction with this internet service provider to block access to a certain website. A file sharing, and this is what has happened to the Pirate Bay, so a very notable website for pirate content. They were issued a blocking injunction to take down this infringing content. And so this is what I wanted to share in relation to online infringements. I don't know if anyone else wants to add to that.
So we have, we have questions from Dr. Aradhana Sadasivam. You can also see the chat box on the right. She's asking that in the context of Europe, is it advisable to protect an invention in the country of head office or in the country of manufacturing? So if anyone would like to answer.
I don't know, maybe Gargi, do you, I think that's in relation to your exposure,
Yeah,
right?
I think I'll take that, but obviously, I mean, the attorneys can chip in. I'm not an attorney, so so basically, I think this is a commercial decision, right? So I would think you should protect your invention in where you think whichever country would be your major market of commercial interest. You would obviously target those countries. You would also, patents are basically a negative right, like it's an exclusionary right. So you would also want to exclude your competitors from making your invention. So you want to target those markets which where your competitors are based out of, and which they would like to sell your product in. So so it's basically a business decision as to where you would want to file patents, where so you would file an EP application and then go national and try to seek protection in whichever countries are of interest to you.
Yeah, I would add too that it's more about where the competitors that are going to be infringing are located. Where's their head office? Where's their country of manufacturing? Yeah. Those are the countries you need protection in because that's your threats for infringement. Patents are, as everyone knows, they're national in scope. So you have to obtain the patent protection where the infringement's going to occur. I mean, ideally.
All right.
Yeah.
So we also have a comment from Rosemary. I would say thank you to Brian for the great high-level review of the key points of the Google versus Oracle U.S. Supreme Court decision.
Thank you.
And from Greg, he says the Google versus Oracle decision seems an absurd stretch of the fair use doctrine, especially when you consider that both Apple and Microsoft independently created smartphone operating systems without unlicensed copying thousands of lines of software code.
Greg, I think Greg makes a strong point, and I'm sure Oracle would agree with him.
Absolutely. So, Michael, do you want to conclude this session in 1 minute?
Yeah, so I thought I mean, I've learned a lot about patents in pharma, and thanks, Brian, for elaborating on the Google Oracle and the decision of the trade secrets. So I thought this was very enlightening, and I would like to thank everyone for listening, for watching, and for the opportunity to speak. So thanks, everyone.
Okay, thank you.
We leave.
So
we have a small surprise. I hope he likes that because it was his birthday day before yesterday, I believe. So just a quick wishes for him from the conference Gorilla and also from all the participants who have joined in. So just wait a second.
All right. Hey.
Thank you.
Thank you.
Happy birthday.
And may all your dreams come true. Happy, happy birthday.
Very nice.
Celebration all night long. May all your dreams come true. We sing all together. Happy birthday to you.
Happy birthday.
Celebration, party night, the vibration, lights are bright, feeling alright, we're dancing till the morning. Happy birthday celebration, everybody gets the temptation. Once again, this is your night, and everyone feels so happy birthday to you. And may all your dreams come true. We sing happy birthday to you. And may all your dreams.
So thank you so much. And belated happy
birthday,
Brian.
Thank you.
From
Thank you, everyone. Okay.
So let's have a
Thank
quick
you.
smiling screenshot before you leave from here, and let's take all the members. So our backstage team, can we take a quick photograph? So we can do this. All right. Thank you so much. Thank you, Michael. Thank you, Brian. And thank you, Gargi, for joining in for today's valuable session. It has been a very informative session, and I'm sure all the attendees have liked that. And participants, before you leave for the session, kindly do the polling at poll section and provide the feedback to the speakers. So I look forward to all of you in our upcoming sessions. So thank you all for joining.
Thank you. Thank you so much. Thank you, Mike. Thanks, Brian.
Thank you.
All right.
Thank you all.
Thank you so much.